Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. Starting with an update from the top court regarding the Delhi liquor policy and the bail pleas of Chief Minister Arvind Kejriwal. As you know, Kejriwal was granted bail by the trial court last week on 20th June. But the next day, the Delhi High Court stayed this order and reserved the judgment on the application filed for stay of bail by the Enforcement Directorate. After this, Kejriwal has now approached the Supreme Court against the order passed by the High Court, staying the operation of the trial court's order which granted him bail. At the commencement of today's hearing, senior advocates Dr. Abhishek Manu Singhvi and Vikram Chaudhary for Kejriwal submitted that the procedure of staying the bail on the first day was unprecedented. Secondly, that the balance of convenience was in Kejriwal's favour. They also took objection to the High Court passing an oral order at 10:30 a.m. itself to halt the bail order as soon as the ED mentioned their petition. They underscored that ED's petition was filed even before the bail order was uploaded and the High Court allowed the urgent listing the same day itself. In this context, Solicitor General Tushar Mehta added that the trial court which granted bail had served as a vacation judge for 2 days. To form a satisfaction, the court had to go through the case record. That the court had begun by noting that it was a high-profile case and recorded in the order that who has the time to go through the record of the case. The Supreme Court today orally commented that the Delhi High Court's approach to reserve order on ED's stay application was a bit unusual. That in the usual course, the stay orders are passed on the spot immediately after the hearing and are not reserved. Instead of passing any order on Kejriwal's petition today, the top court chose to adjourn it till 26th June to await the final order of the High Court. The court said that it does not want to prejudge the issue when the High Court's order is awaited. Coming to a short update on the NEET results controversy. Another petition alleging, among other things, the involvement of National Testing Agency officers in manipulating the OMR sheets was listed today before the Supreme Court in a list of petitions filed pertaining to this controversy. Several petitions were filed before the Supreme Court challenging this examination, as you are well aware. Regarding this petition, right at the outset of the proceedings, NTA's counsel pointed out that a similar writ petition was filed before the High Court. In response, Advocate Ravi Kumar for the petitioner submitted that though this matter was mentioned before the High Court, however, it had refused to hear the same on the ground that Supreme Court was seized of the NEET matters. The vacation bench of Justices Manoj Mishra and S.V.N. Bhatti of the Supreme Court has today adjourned the same to next week after asking the petitioner to withdraw the similar petition filed before the High Court. The Supreme Court today dismissed a petition filed by Haryana Staff Selection Commission against a judgment of the Punjab and Haryana High Court, setting aside a 2022 notification that granted 5% additional marks to domiciles of Haryana in recruitment to certain posts based on socio-economic criteria. The vacation bench of Justices A.S. Oak and Rajesh Bindal was dealing with Haryana SSC's challenge to a judgment passed by the Punjab and Haryana High Court on 31st May, which set aside the notification that awarded additional marks to Haryana domiciles for Group C and D posts under socio-economic criteria. This included conditions like family income below 1.80 lakh rupees, specific familial circumstances, and belonging to denotified or nomadic tribes of Haryana. The court, while setting aside this notification, had observed that the criteria favoured only those with Haryana domicile and residence. Commenting that rules ought to be framed based upon actual data and not political agendas, the High Court held the grant of bonus marks in Common Entrance Test Results 2023 to be violative of Articles 14, 15 and 16 of the Constitution of India and had directed that fresh selection process be carried out. Aggrieved by this, the Haryana SSC and others approached the Supreme Court. But the same has now been dismissed. Justice Oak remarked that the policy of granting an additional 5 marks to a candidate belonging to a denotified tribe in Haryana whose family is not in public employment was only a populist measure to appeal to the masses and deviated from the principle of giving priority to merit. The Himachal Pradesh High Court has cautioned the Shimla Municipal Corporation and Sulabh International of contempt action over allegations that women are being charged 5 rupees for using the free-for-use urinals. A bench of Justice Tarlok Singh Chauhan and Justice Sushil Kukreja observed, thus, while directing the SMC and Sulabh International to ensure strict compliance with orders passed by the court regarding the free use of public toilets. The division bench passed this order while dealing with a suo motu public interest litigation pertaining to the upkeep of public toilets in Himachal Pradesh's capital and establishing amenities along the Parwanu-Shimla highway. The court also directed the authorities to give wide publicity through print as well as electronic media, including the local cable network, to this effect. The Assam government has recently informed the Gauhati High Court that no construction will start in the proposed Ma Kamakhya temple access corridor until due clearance is received from IIT Gauhati as well as other relevant agencies. The Kamakhya Divyalok Pariyojana is a temple corridor project for Kamakhya temple in Gauhati, Assam. It is being developed by the central government. The project will ensure a complete overhaul of the pilgrimage experience at the Shakti Shrine. It is expected to attract a large number of devotees and give a boost to tourism in the northeast. The single-judge bench of Justice Soumitra Saikia was dealing with a writ petition filed by one of the members of the 4 Bor Pujari families who are running affairs of the temple pithas and the adjoining temples. They seek that original structure of the temple should not be disturbed with the construction of this proposed corridor. It is their apprehension that in the process of undertaking the development works, there is an imminent danger of changing nature and affecting the practice of puja offered by the devotees, including the Bodhisattvas. The Advocate General submitted that no construction will start until due clearance is received from IIT Gauhati as well as other relevant agencies, and the apprehension that immediate construction is likely to be undertaken is not correct. The matter is now listed on 24th July. Stay tuned. And now let me tell you, the Bombay High Court has granted bail to a man booked for allegedly stripping 3 teenagers, abusing them and assaulting them with a leather belt. The applicant here is booked under various provisions of the IPC and the POCSO Act. The charges stem from a complaint lodged by the mother of one of the victims. She had noticed a video showing their son and 2 other minors being assaulted and abused. The video allegedly depicted that the accused persons were assaulting and abusing the children after removing their clothes. An earlier bail application by the applicant was rejected by another bench of the High Court, noting the seriousness of the allegations and the presence of video evidence. But after reviewing the FIR and the investigation material, the court found no prima facie evidence of sexual intent. Thus, Justice Anil S. Kilor allowed the bail application, observing that prima facie nothing had been brought on record to show that there was any sexual intent. Instead, the case is about the minors being physically and mentally abused because the applicant and others thought that the minors were thieves. A public interest litigation has been filed in the Allahabad High Court urging the court to direct framing of a comprehensive Mediclaim or healthcare policy specifically for advocates registered with the State Bar Council. The petition highlights the necessity of providing adequate healthcare benefits to legal professionals who often face significant health risks and financial burdens due to the lack of medical insurance coverage. The PIL plea also argues that several advocates met with accidents and other ailments, but they could not get any assistance from the government except some monetary assistance from the concerned bar associations. A bench of Justice Ranjan Roy and Justice Om Prakash Shukla has asked the Uttar Pradesh government to file an affidavit in this regard within 4 weeks. In a related news, the Allahabad High Court recently directed the state government to consider framing an insurance scheme for lawyers appearing for the state government throughout the state of Uttar Pradesh, including before the High Court. To know more on this, do visit livelaw.in. The National Consumer Disputes Redressal Commission, or the NCDRC, has held Maruti Suzuki liable for deficiency in service in a case and held that failing to service a vehicle properly constitutes a deficiency in service. The complainant in this case purchased a Maruti Suzuki Celerio from the Maruti Suzuki India, which was facilitated by an authorized dealer, Bharat Auto Care. Immediately after the purchase, the complainant noticed irregularities in the engine characterized by uneven and rough sounds, which the dealer failed to repair despite multiple attempts. The dealer then charged for unauthorized repairs despite the vehicle being under warranty. Consequently, the complainant filed a complaint in the district forum and sought a refund of the amount paid for the defective vehicle. The district forum allowed the complaint and directed the dealer and the manufacturer to pay the complainant 6,29,000 with interest at 8% per annum. Aggrieved by this, the dealer and the manufacturer appealed to the State Commission of Karnataka, which dismissed the appeal. They approached the National Commission with a revision petition. The Commission has now observed that the dealer displayed a deficiency in service by failing to execute the requisite service on the vehicle and attempting to manipulate the complainant through such modifications without sufficient justification. The National Commission has ruled that the District Commission's order of payment needed modification. It directed the dealer and the manufacturer to pay Rs 4,77,000 with interest at 6% per annum. Consequently, the complainant was directed to return the vehicle back to the dealer. And lastly, the Reserve Bank of India has cancelled the license of City Cooperative Bank Limited in Mumbai, Maharashtra. This decision was made because the bank failed to meet essential financial requirements under the Banking Regulation Act 1949. The bank did not have enough money or steady income, which are needed to protect depositors and follow regulations. Under the provisions of the DICGC Act 1961, depositors of the bank are assured of protection up to a monetary ceiling of 5 lakh per depositor. As per the latest data submitted by the bank, approximately 87% of depositors are entitled to receive the full amount of their deposits from the Deposit Insurance and Credit Guarantee Corporation. Notably, as of 14th June, the DICGC has already disbursed 230 crores to eligible depositors based on claims received. Effective immediately from the close of business on 19th June, the bank is prohibited from conducting banking operations, including the acceptance and repayment of deposits. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.